Lunchtime Politics on Channels Television. I'm Millicent Walker. On the news this hour, a federal high court today gives restraining order asking INEC to hold on the deregistration of political parties. Anxiety as Supreme Court plans to entertain application by the People's Democratic Party and Emeka Ihedioha to review the judgment of the governorship election in Imo State. And protesters stormed the national headquarters of the All Progressives Congress, asking for removal of the national chairman, Adams Oshomole. Welcome everyone to the program. We begin this afternoon from the courtroom where the court is sitting on a case brought before it by 30 political parties in Nigeria, aggrieved of the action of the electoral umpire, that's the Independent National Electoral Commission, INEC, to deregister them. The Federal High Court sitting in Abuja is considering a restraining order on INEC over the delisting of 74 political parties. The court is asking INEC to pause action on 35 political parties, although it was 33 parties that approached it. On the 6th of February, INEC deregistered 74 political parties over the inability to meet up certain requirements as stipulated by law. And to some other court-related political stories, the Supreme Court is this week expected to consider the appeal of the People's Democratic Party and the sacked governor of Imo State, Mr. Emeka Ihedioha, for a review of its judgment on the January the 14th, which removed him from office. Some lawyers and civil society organizations were speaking on the matter and what they think the Apex Court should do based on the fears that it made an error in its verdict. Our political correspondent, Shion Kibaloi, has a report.
January 14th, 2020, the Supreme Court spoke and everything changed. Emeka Ihedioha ceased to be governor, removed, and Hope Uzodinma holds sway as Imo State governor. A month after, the dust is not yet settled, even as the highest court of the land has spoken. A group of lawyers in Lagos State across different civil society organizations are putting some facts forward, insisting that the Supreme Court judgment should not be allowed to stay.
If the Supreme Court has not determined that question of spread, of geographical spread, the Supreme Court cannot make a return.
The issue of whether it can be reversed, yes, the Supreme Court has said so. As human beings, we are bound to make mistakes.
First, they say Senator Hope Uzodinma's declaration as winner of the election is unconstitutional because, according to them, of the provision of Section 179, subsection 2 of the Nigerian Constitution. That portion reads, for a candidate to be declared as duly elected, he or she will not only have to have the highest number of valid votes, but also should have a spread of 25% of the votes in 2/3 of the local governments in a state. In the case of Imo State, 2/3 of the 27 local government areas is 18. On the flip side, they are also arguing that Emeka Ihedioha of the PDP did not also meet the constitutional spread required by the Constitution, having scored 25% in only 14 out of the 27 local government areas.
Either the PDP's candidate or the APC's candidate had 2/3 across the state. PDP had 14, APC had 2. So if we are even saying 14 didn't get it, how then does 2 get it?
And this is what these lawyers and rights groups are asking for.
You must do a rerun.
The case is expected to be appraised on Tuesday by the Supreme Court, but it appears whatever decision the court comes out with is still the ultimate. Shion Kibaloi, Channels Television News.
Let's now get some perspectives on the matter. From Abuja studio, we have Mr. Fred Nzako. He joins us there. Also here in Lagos, we have Mr. Inibehe Effiong. We'd like to thank you both for joining us on Lunchtime Politics. Let's begin with you in Abuja. And that is, you know, many people are asking, it's tomorrow, Tuesday, former Imo State Governor begins a quest to convince the Supreme Court to revert itself on the judgment sacking him from office. How long do you think the process will take? Will the former governor succeed? Mr. Nzako.
Important is that what is done well. What is important is that we don't leave an issue to be hanging for posterity. It is important that if there is an error, because we are all human beings, if there's any error committed, that such error is corrected. It is better for Nigeria to correct an error than to preserve an error, all in the name of preserving the sanctity of the opinion of the Supreme Court. The error that is manifestly committed here is a human error. I do not hold anybody responsible for that because nobody is God. Nobody, we are all mere mortals. We can make mistakes. The mistake made by all parties in this issue is that the two conditions which must be met before anybody is declared elected as a governor, as provided in our Constitution in Section 179A and B, is that one, you must have the largest number of lawful votes, and two, you must have 25% in at least 2/3 of the state. That is sacrosanct. These are all constitutional matters. It was there in 1979 Constitution, which was the predecessor of 1999 Constitution, and it is there in 1999 Constitution, and since 1999, it has been always respected. In this particular case of Imo State, neither the APC nor PDP had met the constitutional requirement of spread. And what it now means is that the two legs upon which the seat of the governor is standing, one leg is broken. And if one leg is broken, there's no way that seat can stand.
Let's talk to our guest in Lagos.
That this is an opportunity for the Supreme Court to right the wrongs.
All right, Mr. Effiong, do you agree? Do you think this is a big error, human error, as our guest in Abuja has said?
Well, the matter for me is not as simplistic as my learned friend has presented it. I have carefully read the judgment of the Supreme Court on the Imo gubernatorial election. And I understand the argument about geographical spread. But we must start by making the point that by virtue of Section 235 of the Constitution, the principle of finality of determination of decisions of the Supreme Court is enshrined in that no appeal shall lie to any other authority or person from any determination of the Supreme Court. But the argument has been made that this is not an appeal. This is an application for a review. But there's also the argument, what can be reviewed? Is it just clerical errors? Can the Supreme Court, in an application for review, change the substance of its decision? I have read the judgment on the Imo gubernatorial election. This whole point, this whole debate about 388 polling units, which the APC candidate claimed were unlawfully excluded, that argument had been canvassed at the tribunal and at the Court of Appeal. And I realized, unfortunately, that INEC, the electoral body, had clearly failed to prove his case as it relates to the exclusion of those results. If you are saying that INEC did not dispute that elections held, INEC said they were elections. But he now said, no, the results brought were forged. We were going to produce the original. But they failed to do that at the trial. So on the issue of pleadings of the parties, the Supreme Court seems to be right on the point that the argument was not whether results in the contentious polling units, the elections were properly done or not, but whether results were excluded at the ward level. Now, what are the requirements to make a return under Section 179? First, the candidate must have majority of lawful votes. That is not in dispute because the Supreme Court has now said that by excluding results from those 388 polling units, that the candidate of the APC had majority of the lawful votes. There is a second requirement of geographical spread, which is that the candidate must have 1/4, at least 25% votes in 2/3 of the local government. In the case of Imo, of the 27 local government areas, the candidate must score 25% votes in at least 18 local governments. I read the judgment of the Supreme Court carefully. I did not see any pronouncement on that. Does that mean that there was no geographical spread? I have read the application for review. I have looked at the affidavit in support of that application. I don't want to make prejudicial comments, but the question still remains, what basis, what parameters, where is the calculation that determines the geographical spread? I haven't seen any. But I want to submit that if the Supreme Court, in its wisdom, finds that indeed the question of geographical spread is germane, it will not be out of place for the Supreme Court to look at the matter a second time.
Mr. Nzako, if I may, you might want to react to some of the things Mr. Effiong has said, some of his arguments on this issue, but I'd also like to get your point of view on what you think the Supreme Court will be looking at tomorrow. And this is following what indeed the former governor, Ihedioha, has filed and brought before the court, because we know the court won't impute what isn't before it. In this case, to help his case in the review of that judgment.
When an issue becomes issue of law, when an issue becomes issue of a breach of constitution, don't forget that everything we do is dependent on the constitution. The Supreme Court itself is a creation of the constitution. The office of the governor is a creation of the constitution. So the constitution that is the ground norm must always be respected and protected. And if eventually anything that is a breach of the constitution, the Supreme Court on its own, on suo motu we call it in law, would direct that such breach must be corrected. So even if neither party, whether PDP or APC, brought the issue of spread, it lies in the purview of the court to direct that such be respected. I'm happy that my learned friend Inibehe did not oppose the issue of the second leg of Section 179 of the Constitution. And by so doing, what the Supreme Court should do now, without prejudice, with due respect to the learned justice of the Supreme Court, is to direct INEC to reconduct this election. You can call it a by-election, you can call it a rerun, but the two major parties must go back to the field such that a credible governor who is sitting on a seat with two legs will be produced, and not a governor that will be sitting with one leg. Such a governor cannot lead the state. And then the terrible aspect of it is that if this is not done, a terrible precedent will be set. What it now means is that sometime we have surreptitiously on which requires that a governor must be widely acceptable in a state that he intends to lead. That is the spirit and intent of the law. That geographical spread, so that the governor will not, wait a minute, so that the governor will not go and get the votes from only his community or his local government and come and lead the entire state.
I'd like to get summarily your thoughts as we wrap up this discussion, because time is not our friend. And this is, if we think that the Supreme Court has put itself in a position where Nigerian citizens are now questioning its pronouncements, you know, to members of the bar and the bench, isn't this a precarious situation? Briefly.
The Supreme Court, per Justice Oputa, famously said in 1989 that we are not invaluable because we are final. We are final. We are not final because we are invaluable. We are infallible because we are final. My recommendation to the learned justices of the Supreme Court is this. Invite INEC to state on record in reaction to this application for review. Let them bring an affidavit before the Supreme Court to show the geographical spread of Mr. Emeka Ihedioha and Hope Uzodimma. If that point is not resolved, it will be important for the Supreme Court to look at it and determine whether a person can become a governor in Nigeria without a clear pronouncement that the geographical spread had been made.
And finally,
it is an important issue.
Finally to you, Mr. Nzako, your final thoughts. Do you think the judiciary is on trial? Briefly, please.
At all times, whenever political issues become contentious, the judiciary is on trial. But I want to say with due respect that judiciary has always met up to the expectations of Nigerian people, especially the Supreme Court has lived up to expectations of Nigerian people. And this time around, we expect that such expectation will not be dashed. Because what is important is that we solve the challenges of today for the posterity and for the future. Because Nigeria, as an entity, will continue to exist. Democracy has come to stay, and it has to stay very well.
We
and
appreciate
not
your
to be
time,
thwarted
legal practitioners in the
recklessly,
studio.
In this case, as we are saying.
Many thanks, Mr. Fred Nzdako and Ms. Ainihebe Efyong. Thank you so much for joining us at this time. We'll take a break. Still to come on Lunchtime Politics. Protesters storming APC National Office in Abuja. They're seeking the removal of the party's national chairman. We have more when we return.